Good afternoon and welcome to the Cato Institute. I'm David Bowes and I'm Vice President for Public Policy Affairs at the Cato Institute. I'm glad to see such a tremendous turnout for the forum today, and I just apologize if there are any of you who don't get seats because I can see that we are oversubscribed. We do still have, I think, one seat up front here, and there may be one or two more in the back. We do have a speaker set up here so people will be able to hear from the backyard, and you're welcome, if there are people coming in now, to stand out there. It does appear that we had a bigger turnout here than we anticipated, so, isn't it? Now is it on? Okay. All right, now we have a speaker set up in the backyard. As many of you know, the Cato Institute is a public policy research organization. We publish 6 to 10 books a year on topics ranging from Social Security to inflation to military spending. This summer we've published important new studies on Social Security and on the failure of national economic planning. We also publish the Cato Journal 3 times a year, as well as a newsletter and a series of shorter public policy studies. The most concise end of our public policy commentary is our daily radio program Byline, which is heard on some 200 stations. Here in Washington, of course, one of our most important forums is the Cato Policy Forum, and I think we've got an especially interesting program for that today. The Attorney General of the United States has established a commission on pornography to investigate whether new legislation regarding pornography is warranted. There's been some concern raised as to whether the members of the commission have already made up their minds on that score before the investigation begins, and I'm sure that's one of the questions that will be raised by members of the audience today. At the Cato Policy Forum, we like to provide a forum for differing viewpoints. Those of you who know of our libertarian orientation, or as we define it, our interest in preserving and expanding both social and economic freedom, will not be surprised to know that we have a definite presumption in favor of the First Amendment and an expansive view of it. However, in keeping with one of the first advocates of free speech, John Milton, we believe that truth will usually win out in free and open debate, so we intend to provide a scrupulously fair forum for both sides today. Certainly, we've managed to attract an audience, as you may have noticed, that includes vocal advocates of all sides of this debate. Before I introduce our speakers, I just want to run over briefly the format. We'll have 20 minutes for each of our speakers to present his case, followed by 5 minutes for a rebuttal or response by each speaker. And if we keep to that schedule, that should allow us about 30 minutes for questions at the end. Because of the large number of people in the audience, we'd like to ask you, when you ask a question, to identify yourself and your affiliation and ask a short, direct question, no statements from the floor, given the size of the crowd. And after the question period, you're all invited to join us in the backyard for a reception. All right, with that, I'll turn to the business at hand. Our first speaker to present his view of the issue for 20 minutes is Henry Hudson. Mr. Hudson is Commonwealth's Attorney for Arlington County, Virginia, just outside Washington, and is Chairman of the Attorney General's Commission on Pornography. Our second speaker following that will be Barry Lynn, who is Legislative Counsel for the American Civil Liberties Union and a longtime lobbyist on civil liberties issues. As both a lawyer and a minister, he should have a unique perspective on this issue. Mr. Hudson?
Thank you very much. I appreciate the opportunity to be here today, but unfortunately, as the chairman of a national study commission, I'm really here under somewhat of a disability. As chairman of a study commission, it's our function to harvest evidence and draw conclusions. And since I have not as yet heard the evidence which our commission intends to have presented, I'm really not in a position today to comment on the evidence or to state any conclusions about what we're going to find. Now, I realize the theme of today's discussion is pornography and what should be done about it. The difficulty that I have, perhaps in being as effective as I could be, is that I can't fashion a cure until I determine whether or not there is a problem. Now, the Attorney General's Commission on Pornography was inspired, as you know, by comments that attended the signing of the Child Protection Act of 1984 by President Reagan. At that time, the President indicated that he felt that pornography in 1984 was far more sexually explicit and more violent than it had been in previous years. Attorney General Meese shares that view. And in conformity with that, he commissioned myself and the 10 other commission members to study the pornography problem. And there are a number of sub-issues which we're going to consider. First of all, we're going to determine whether or not pornography is more violent today than it has been in the last 14 years. And we're going to determine whether or not its nature has changed, whether or not it's more sexually explicit in 1985. In addition, we'll want to take a look at the behavioral effects of pornography. Does pornography have a definite, well scientifically defined effect on human behavior? What effect does child pornography have on children, as well as people that may be predisposed to use child pornography? We're going to take a look at whether or not modern technology and the increased accessibility of pornography has had an impact on our society in 1985. We're also going to review the production of pornography and its method of distribution. We're charged also with the responsibility of determining whether or not organized crime has any connections with pornography. Should we determine that there is a definite relationship between pornography and our society today, whether or not it has an adverse impact on people, whether or not with a good scientific and empirical basis we can say that it does cause adverse behavior, then we're charged with the additional responsibility of coming up with recommendations to the Attorney General about perhaps increased law enforcement initiatives or maybe even statutory changes if we think that may be appropriate. Now, the vehicle we're going to use to harvest the evidence to determine whether or not any of these areas warrant further public action or official action on the part of the Department of Justice will be through a series of public hearings. The first one, as many of you know, was conducted last month in Washington, D.C. That was an introductory hearing at which we reviewed some of the sub-issues, tried to determine whether or not there has been a change in the nature of pornography in the last few years. Our hearing week after next in Chicago is going to focus on law enforcement initiatives. What is law enforcement doing in the pornography area? We have 3 additional public hearings. One of them will be in Los Angeles, one of them will be in Miami, and one of them will be in New York. At those hearings, we're going to look at the production and distribution of pornography, child pornography, the behavioral science aspects of pornography, and whether or not there is an organized crime connection with pornography. Now, ladies and gentlemen, contrary to what you may hear in some quarters, our commission is not charged with the responsibility of trying to design a national standard or definition of pornography. I think every one of the commissioners agrees that the definition already fashioned in Miller versus California is an acceptable one, the 3-pronged test devised there. So to the extent that there is criticism that our commission is going to be trespassing on First Amendment rights, I will tell you that we intend to utilize the standard developed by the United States Supreme Court in Miller versus California. And as you know, that leaves it to each individual community to determine what offends their standards in accordance with state law. Utilizing that standard of measure for pornography, we're going to determine whether or not pornography has an adverse impact on society. Does it affect human behavior adversely? Now, I think there, as you'll glean very quickly, are a lot of clear-cut divisions between our viewpoint and the viewpoint of Mr. Lynn. The viewpoint of the ACLU is that the First Amendment has no bounds of prescription on pornography, that any type of literature, any type of portrayal of sexual activity ought to be lawful. Well, I think I can say that for myself, I believe that some type of reasonable restriction is necessary, as has been recognized by the U.S. Supreme Court in the Roth case. Somewhere you've got to draw a line in the sand as to what is and is not the criminal display of sexual activity. And we also support very much one of Mr. Lynn's basic notions, and that is that in a democratic society today, there ought to be a free and open expression of ideas. But what concerns me and some of the other members of the Commission is whether or not the publication of literature or movies which depict women bound, gagged, and chained, being flogged to the point of bloodshed, or a 6-year-old child engaged in sodomy with an adult, whether or not that expresses an idea. That's something we may wish to take a look at. But ladies and gentlemen, at the end of our study, if we determine that pornography does pose a well-defined problem, and when I say well-defined, I mean, in the opinion of recognized scientists, that there is a relationship between pornography and certain types of deviant criminal sexual behavior, then the Pornography Commission will come up with specific recommendations on what corrective action ought to be taken. That, ladies and gentlemen, is going to be an issue, though, for a later day. Thank you very much.
Thank you, Mr. Hudson. Now we'll hear a differing viewpoint from one of the leading critics of the Pornography Commission, Barry Lynn.
Well, I don't have the constraint that Mr. Hudson does, and I have a series of opinions which I'm happy to disclose to everyone. And I'd like to thank the Cato Institute for extending me an invitation to participate in what I think is a very important debate. The only sticking point I had for my acceptance was David Bose's insistence for a while that I wear sunglasses and a raincoat today. There is a war on pornography going on in the United States today. In Los Angeles, producers of adult films are being charged under pandering laws, under the theory that the women in their films are being paid to have sex, not to act. The federal government has just brought its first dial-a-porn indictment against the people who provided the service of a 1-minute erotic tape telephone message broadcast out of New York, as well as indictments against the woman who made that 1-minute tape. That suit was filed in Salt Lake City, Utah, which I'm sure was just a random venue chosen out of a hat. Now, just 2 months ago, FBI agents have actually started for the first time to muscle in on something that Mr. Hudson has done, and that is close down businesses in X-rated videotapes. In a series of 24 coordinated raids, FBI agents in Memphis, Tennessee, went into stores to rent such cinematic classics as 1001 Erotic Nights, to say nothing of Casino of Lust, and they returned bleary-eyed the next morning with their returned tapes and, surprise, a search warrant to go through those stores to find out whether there might be records in those stores of interstate transportation of obscene material. And then just last October, the Customs Service convinced the United States Postal Service to undertake a little experiment. They diverted mail bags from certain Scandinavian countries away from the normal port of entry, New York City, to Wilmington, North Carolina. You see, the 1930 Import Act forbids importation of obscene materials, and it has been held to mean that the alleged obscenity is to be measured by the community standards of the port of entry. Customs officials apparently thought that the nation would be better served by allowing nothing to pass the borders of the United States which was unacceptable in Jesse Helms' backyard. Well, the Postal Service went along with this experiment for about 2 weeks, then decided it in fact delayed the mail to do so and ended the experiment, although customs officials still want that process of mail opening in North Carolina to continue. All of this is being done right now with a wide variety of federal and local laws and statutes. We have over 30 federal anti-obscenity provisions, including one that makes it unlawful to have an obscene picture on a cigarette package. All of these laws without any need for a new commission. Yet here we have the Department of Justice shelling out $500,000 to the commission, and according to the Commission's charter, it is designed to make specific recommendations concerning more effective ways in which the spread of pornography could be contained. So I believe I'm justified in fearing that we're going to see proposals for a wide new array of legal initiatives to curtail the right of Americans to see and read what they choose. For the ACLU, one of the very bedrock principles of this country is its unfailing commitment to the full and free open expression of ideas. That's what the First Amendment is all about. It means that some very reprehensible ideas are expressed and that some very, very unattractive means to express them are going to be used. Nevertheless, whether material appeals to one's highest ideals or basest instincts, And whether it does so through rational discourse or very emotionally charged images, the First Amendment guarantees that it be allowed to take its place in the universe of debate. The First Amendment does not guarantee that we'll locate the truth, but any time you diminish its promise, you make it far more likely that the truth, whether it's truth about religion or politics or even sex, will be able to prevail. I don't think there's any substitute in our system for the competition of ideas. And those people who find the image of women portrayed in some pornography to be a grotesque caricature, those people who find the message of casual sexuality in pornography to be highly offensive to their moral standards, have every right and responsibility to critique the use of the material and to urge that it not be used or viewed by anyone. But if they fail to succeed in convincing people not to read this material, I think they should not be coming to government asking it to impose their viewing standards on all of us. The 1970 Commission on Pornography urged the repeal of most existing laws to regulate adult access to this material. I think that it was making lines in a very good and clear direction. Unfortunately, Supreme Court decisions since 1970 have continued to carve out exceptions to the First Amendment in regard to sexually oriented material. And in the guise of creating standards for obscenity, the court has in fact legitimatized a kind of moral mob rule where citizens who are offended by what their neighbors might be looking at are able to use the judicial system to suppress those offending ideas. The fundamental problem with which we begin is that censorship has now been justified by the Supreme Court. It's been sanctioned for no reason other than the intolerance of the majority. The Supreme Court has said obscenity can be regulated. It hasn't said it must be, and I think we'd get our money's worth from this commission were they to continue with the view of their predecessor that we need to work to end restrictions on sexually explicit speech. That most recent test of obscenity that Mr. Hudson has approved of means that publishers, theater owners, and booksellers today have to make these judgments: whether the material appeals to the prurient interest as judged by the average person applying contemporary community standards, whether it describes or depicts in a patently offensive way specific sexual conduct, and whether as a whole it lacks serious literary, artistic, political, or scientific value. Those phrases do not have plain meanings, and contrary to the views of Justice Stewart, it is not easy to know it when you see it. In fact, the voluminous litigation and erratic course of obscenity law since 1973 shows that there are many juries of average citizens and many federal judges who apparently don't know it when they see it either. After 12 years, there are a multitude of unanswered questions about what this definition means. It was only 3 weeks ago that the Supreme Court in Brockett versus Spokane Arcades said that prurient interest could not be defined by state law as simply inspiring normal lust, because prurience referred only to lascivious sexual arousal. Now, I don't know what that means, and I don't know what the difference is, but I'm sure if you paid somebody $500,000, they could tell you. Now, this and numerous other issues of this morass of law about what obscenity means has caused some people to say, we need to fix the definition, we need to expand it, we need to change it. And they are, in fact, urging the Commission for its approval of all kinds of new methods of suppression of sexually oriented speech. The suppression theories and the proposed mechanisms, I think, are endless. Paul Wyrick's Free Congress Research and Education Foundation issued a report recently that said pornography should be curtailed, among other things, because it hurts marriages. The theory seems to be that both men and women who look at porn see attractive people doing interesting things. They then look at the people that they are sleeping with and get dissatisfied and then divorced. Their solution? Quote, pornography is treason against the American family. Treason has no First Amendment rights. Senator Tribble of Virginia wants computer hackers prevented from writing dirty fantasies to each other on their computer screens. Senator Denton wants distribution of any profane words or indecent pictures on cable television to lead to fines and 2 years in federal prison. Some radical feminists want pornography defined as the graphic, sexually explicit subordination of women to be actionable under civil rights laws. Any person who traffics in the material can be sued by anyone who doesn't like it. All of these constructs, old and new, can in fact be construed even by very reasonable people to cover vast amounts of literature, art, and popular culture in today's society. And that really is the essence of a chilling effect, that persons will not write or publish or sell because they do not want to risk that some particularly sensitive or particularly zealous individual will decide that their product is covered by some broad statutory language. Self-censorship in this way can have as drastic an effect on the free flow of ideas as direct government censorship through prior restraint. Much present and proposed regulation of this material rests on the premise, and I think Mr. Hudson has adopted this premise, that sexually explicit material contains no ideas. It's just some kind of emotional stimulus which is not given any protections under the First Amendment. I think that's a dangerous and wholly false assumption. Sexually explicit material usually communicates that the activity depicted is pleasurable and appropriate. Put very bluntly, it asserts that it is good and healthy for persons to engage in sex with many people in many places and many positions. And I would hope there would be a profound moral debate in this country about the legitimacy of that as a philosophy. Now, it may also communicate a more sinister message, as some feminists have noted, that men should gain pleasure solely from the subordination of men. But to say that that issue and to say that that construct, which has held sway in Eastern and Western cultures since the beginning of human history, is not an idea with protected under the First Amendment, I think is to do a great disservice to the very concept of political speech. On the other hand, the social message of sexually explicit material may not be so unhealthy. In fact, it can be viewed by some people at some times to be quite beneficial to their self-identity and self-understanding. In fact, now that pornography, as Mr. Hudson pointed out, has changed, it is no longer exclusively interested in one body part, breasts, of one sex, female, of one age category, quite young but not too young. It suggests that everybody, yes, even pregnant people, even men, can be sexual beings. Is that all bad? Is that all a wrong or unhealthy message to communicate? I suspect it isn't. In addition, for sexual minorities, material which depicts their non-abusive lifestyles can be a means of their own self-affirmation. The fact that pornography asserts what it wants to say graphically rather than rationally doesn't take it out of protection of the First Amendment. That's what the Supreme Court, I think, recognized in the famous case of Cohen versus California, where it assessed the impact of Mr. Cohen entering the trial court wearing a jacket which was emblazoned with words strongly suggesting that people have intercourse with the Selective Service System. Court said, we cannot sanction the view that the Constitution, while solicitous of the cognitive content of individual speech, has little or no regard for that emotive function which, practically speaking, may often be more important. This attempt to create a false dichotomy between stimulus and idea carries the seeds of an effort to totally rationalize human sexual conduct. It dispenses with any thought that there may be any positive or healthy aspects to human fantasy, perhaps the most intimate form of human expression. Fantasy imagery allows us to experience in our imagination ways of being that we might not want to experience in real life. And I'd submit that it is just as dangerous to allow the state to police our fantasies as it is to allow them to police our politics or our religion. Let me turn just for a moment to some of the asserted reasons for the creation of this new commission. First, the sheer volume of pornography has certainly increased in recent years, but pornography, words and pictures about sexuality, comes in many forms, good, bad, and ugly. And I think we have seen, and the Commission's seen, plenty of examples of things in all categories. But that 1970 Commission also found that the reason that so-called pornography caused so much controversy was the inability or reluctance of people in our society to be open and direct in dealing with sexual matters. So more is not necessarily worse. It could reflect nothing more than an increased willingness on the part of Americans to discuss sexuality. And if there is indeed an $8 billion business in what could loosely be called pornography, then there are clearly an enormous number of Americans who think they are benefiting from it. And what right does the government have to cast its opprobrium on those beliefs? I'd say none. Now, the Attorney General suggested, too, that there was more sexually explicit material available through technologies like video recorders and cable. I think that development has a couple of important ramifications. First of all, these devices now allow you to do in the privacy of your home what you used to be able to do only publicly in so-called adult stores. Consequently, I think it should be even clearer that constitutional rights will be implicated when restrictions on availability occur. So even if the government has an interest in how its people publicly entertain themselves, something that Ed Meese has suggested, it should have absolutely no interest in the private activities which occur behind America's closed doors. Second, I know there's a concern that some of these technologies make sexual material available to children. The ACLU certainly affirms the right of parents to have controls over what their children see. We've even recommended that cable operators be required to provide lock boxes so that parents may block their children from seeing what they consider objectionable services. I know that people would go much farther than that, but if cable companies are statutorily prohibited from showing nudity, or if sexually oriented magazines are blocked by opaque covers, then I think Justice Frankfurter's admonition comes quickly to mind. He said the risk is to reduce the adult population to reading only that which is fit for children. Yet another justification that Mr. Hudson has suggested is the asserted change in the nature of pornography. Well, there are some studies that suggest there is more violence now depicted in these magazines and films, but it's still clear that the vast majority of this material simply features images of consenting adults participating in voluntary sexual activity. Bestiality and mutilation is not the mainstay of pornography. There was a lot of testimony before the Commission about so-called victims of pornography. There's no doubt about the personal tragedies of persons involved in sexual assault, rape, incest, and spouse abuse, because we do live in a society that has a persistent sense of violence against women, and where law enforcement officials too often do not treat intra-family violence as a very serious matter. But when we look at specific claims of victimization, I think it's important to determine what is the real cause of that abuse, so that symptom control does not become the substitute for genuine remedies. There are people who have suggested to Mr. Hudson's commission that pornography has somehow triggered an individual to behave aggressively. It's undeniable that there are media representations of violence whose elements are replicated almost identically by persons during the commission of a criminal act. But those isolated occurrences do not permit broad intrusions into First Amendment rights. The First Amendment may not be suspended because the most suggestible person who sees an image or hears an idea acts in an antisocial manner. A return to that pre-1957 standard would put at jeopardy far more than pornography. The Burning Bed was the most widely viewed television movie in American history. It literally empowered tens of thousands of women to call and get help for the kind of abusive relationships in which they had now found themselves or had found themselves during their lives. But one man who saw that film set his wife on fire, mirroring the action of the abused wife against her husband in the film. Under some First Amendment calculus that's heavily weighted for even a single adverse effect, this too should be restricted. Vicious sex crimes can be linked and have been linked to triggers as diverse as an Episcopal church service and the golden calf scene in Cecil B. DeMille's Ten Commandments. Ironically, the more pathological an individual is, the less likely you will be able to determine what will set him off. So pedophiles who have been arrested are frequently found to have not just commercial child pornography, but also scrapbooks containing department store underwear advertisements from Sunday newspapers. If the measure of suppression was what material caused one person to do, we would all be reduced to sitting in darkened rooms to prevent some errant image from crossing the eye of that one person who might react in an antisocial manner. There are things you can do for victims, for genuine victims of sexual abuse, and the ACLU has certainly been in the forefront of organizations fighting for those things, for a Civil Rights Act that permits persons who have material displayed in front of them in their workplace, making it difficult or impossible for them to stay on the job, to have a remedy under Title VII of the Civil Rights Act to force that kind of conduct to cease. We've opposed spousal immunity provisions in sexual assault laws so that even if it is your husband doing the bad things to you, forcing you to do the things that he finds and brings home in his pornographic magazines, that you have a remedy, not against pornography, but against your abusive spouse or lover. All those things, real remedies for real problems, all of them can be accomplished without impinging on the First Amendment. I think the Commission's charter also states an interest in looking at new laboratory data connecting sexually oriented material with antisocial conduct. I think there is absolutely nothing in this new literature to suggest that there is a justification for eliminating material under any basis or under any theory that the Supreme Court has ever adopted. The Commission, I know, was told that in a sample of serial murderers, 81% of them noted a high interest in pornography. This is the kind of evidence that the Commission is getting. I just think that the Commission is not clearly able yet to recognize that sometimes the presence of two phenomena, like criminal activity and pornography, does not necessarily demonstrate a causal link between them. It's at least as likely to demonstrate that persons with certain abusive personalities are attracted to both crime and the use of pornography. The fact that most people die in bed does not necessarily lead to the conclusion that mattresses are lethal either. I think this Commission has every right to exist. I think there are many questions about whether it is necessary, useful, or appropriate, but it certainly has a right to inquire in any way into this whole phenomenon. What, if anything, can be done about pornography? I think the only thing that can and should be done is that those who find some or all of it to be rotten speech should try to displace it with quality speech. Where women are portrayed in a demeaning fashion in pornography or in dishwashing commercials, the public can demand and can get alternative and affirmative images. But when anti-pornography advocates come to Mr. Hudson's commission bearing new weapons of suppression, I get very nervous, and I think they too should be forewarned. Censorship in the hands of the state quickly becomes an unstoppable impulse. Majoritarian tyranny in the name of morality or feminism or paternalism, all of it is a repudiation of the liberty of self-affirmation, which I think is the very cornerstone of American freedom. Thank you.
Thank you, Barry. Henry, I think you're a few minutes behind if you want some rebuttal time here.
Thank you, Dave. Ladies and gentlemen, I want to make sure you understand the full import of what Mr. Lynn is saying. And I think maybe his views at times may be masked by his extreme examples and his seasoning of his remarks with some humor. But what he's basically saying is that he does not believe that there should be any restrictions whatsoever on any form of literature or any form of publications. And you know, I think one thing in the legal profession that many times we have to remind ourselves, and something I do during the course of a lot of trials, we have to remember that in applying legal principles, we have to use a little common sense as well. Folks, under Mr. Lynn's idea, not only would no type of publication be controlled in any fashion, but he's also saying that he sees nothing wrong whatsoever with child pornography. You should be free to distribute that anywhere in society. What he's telling you is this, that it's up to the parent to control pornography. In other words, if your child encounters someone on the street and they give him a piece of pornography, that shouldn't be the problem of the man that gave it to him or the lady that gave it to him. That's the parent's problem. Well, I think we can only go so far in our society today in the parent's responsibility for taking care of the child when he's away from home like that. I think we have to create an environment that's also healthy for the child and assists in raising children in accordance with the values that we have had instilled in our society over the years. Now, I would agree with Mr. Lynn that our commission is not in a position at this point to draw any conclusions from the evidence that we've heard. I told you that during my opening remarks. I think we're going to have to wait till all the evidence is in before we come up with any recommendations. But you know something? If you ask him, he'll tell you. If we come up and we prove beyond a reasonable doubt, with reasonable medical certainty, that there is a definite correlation between certain types of violent pornographic materials and exploitive sexual activities. In other words, we can show that 99% of the violent rapists in society today drew their ideas from pornography. I'm not saying we can prove that. This is for the sake of discussion. Mr. Lynn would still tell you, no, I don't believe pornography ought to be controlled. And you know, he tells you that the Miller versus California and similar types of cases have had a chilling effect on publishers throughout the United States. Well, ladies and gentlemen, when Hoops Townsend, who is the director of the American Publishers Association, testified before the commission, Commissioner Ellen Levine, who is the editor of Women's Day magazine, specifically asked Mr. Townsend whether or not the present definition of pornography has had a chilling effect on writers and publishers today, and his answer was no. He also complains that the majority mob rule shouldn't govern here. Well, that's a nice fancy term, folks, but you know, in democracy in the United States, as far back as its initiation, the majority has always been the one whose wishes fashion laws. And the same type of majority rule that imposes some type of restrictions on certain types of offensive publications is the same type of majority rule that doesn't allow a person to raise hogs in a residential neighborhood, the same type of restriction that doesn't allow you to drive your car at 100 miles an hour in a residential neighborhood, and the same type of restrictions that doesn't allow you to sell drugs in our society today. So what I'm basically saying is that the same type of consensus of society that governs in every other aspect has an effect on what type of literature is to be distributed in our society. It's based upon what type of attitude, what type of morals we want in our society today. And ladies and gentlemen, I'm not saying that the Pornography Commission will adopt one viewpoint or the other when it comes down to the bottom line of making decisions. But what I'm going to tell you is that in reviewing the issues in that case, we're not only going to review the evidence and review the law, but we're going to use common sense. Thank you very much.
Barry?
No, but I get the distinct impression, Mr. Hudson, that you're not going to recommend anybody in the ACLU for the Congressional Medal of Honor either. I'm the one who uses extreme examples. I don't know. If you think that the production or the distribution of Playboy magazine is just like driving 100 miles an hour in a residential neighborhood, selling heroin or raising hogs, I'm not sure that I can be adequately or fully criticized for using some extreme examples. In fact, the very quality of this speech, the very issues, the ideas communicated in this material, as I said earlier, and as every clinical and sociological study has demonstrated, does not change very much over the years. In fact, there may be a slight increase in the amount of violence, but basically we are talking about people engaging in voluntary sexual activity for which there should be aesthetic and moral debate and no federal or state legislation. Common sense, I think, also tells you a few other things. If you look at all the clinical studies, and I've read literally hundreds of these studies, common sense also suggests that there are lots of people, I won't look, but I'll bet that if I turned around here and said, would anybody who ever saw pornography raise their hand? I bet a few of you have seen it. I bet that you have not, in fact, become a psychotic rapist. You have not become a person who is insensitive to your neighbors, who does not care about people. I suspect that you have processed the pornographic images along with the trillions of other images that cross your mind every day, and that it has had virtually no effect on any of you. There's nothing magical about pornography, nothing magical at all. Well, Mr. Hudson says they're going to look at all of this material, and I think they will. I think, however, that the charter of the commission, of which he is the chairman, suggests both that the assumption is made that there is, in the words of the charter, a serious national problem of pornography, and that this organization is in the process of finding new ways to curtail the spread of that material in our society. Democracy means one thing to Mr. Hudson. It apparently means something different to me. Majority rule, is that what democracy is all about? Not quite. That might be what it's about without the Bill of Rights. But with the Bill of Rights, it is absolutely clear that you do not take a plebiscite on individual liberties, that the majority does have some rights, and that the First Amendment exists to moderate the otherwise unstoppable impulse of the majority to get its way in matters of sex and politics, religion, and everything else. Thank you.
Okay, with that, I think we've set out the issues pretty well here, and we'd like to take questions from the audience for either or both of our speakers. As I said before, please identify yourself and your affiliation, and keep your questions short and direct. Yes. Bert.
Bert Ely, financial consultant. I have a question for Mr. Hudson. To what extent is your commission going to explore the phenomena that a number of people have noticed over the period of time, and that is that attempts to suppress one type of activity or another in a legal manner actually tend to increase the amount of that activity, both because of the titillation factor and also because the marketplace comes into play and finds it generally more profitable to go out and market and distribute those materials that are in fact held in some form of legal contempt. And drugs, of course, are a very good example of that.
Well, I think to an extent your observations may have some merit, and it certainly is something the Pornography Commission is going to consider along with all the other evidence that's going to be presented to us.
Yes.
A question for Mr. Lind. I'm Kim Reynolds from Capital Legal Foundation. If Mr. Hudson is correct, you would not oppose any control on child pornography, and I'm wondering what your objection would be to controlling the use of children, the abuse of children in pornography.
Well, we don't have any problem in controlling the use and abuse of children and trying to stop it. The problem is, once the material is made, once you've got that image out there in publication, then we think the First Amendment's free expression guarantees are triggered and that the material itself is protected. Now, the Supreme Court does not agree with that position, and I think that, in all honesty, should be made clear. On the other hand, in spite of Congress's insistence in the past 2 years to pass 2 new federal child pornography statutes, the level of sexual child abuse in this very violent society has continued to rise. Dirty pictures involving children are not the cause of sexual child abuse in this country, and as long as people continue to make rhetorical capital out of talking about kiddie porn, they're not going to do the many things that should be done to curtail the actual abuse of children, whether it involves cameras or uncles or anybody else.
I'm not suggesting that child pornography causes people to abuse their children or people to abuse children. What I'm saying is that the use of children in that medium is not proper. They are not adults, they cannot speak for themselves, and it's very likely that they'll be harmed in that process.
Well,
how do we protect those children? Is that a First Amendment issue?
No, the only thing that's a First Amendment issue is what happens when the material has already been made, the abuse has occurred, and the magazine is out there in distribution. That's the only thing that is protected by the First Amendment. The First Amendment gives child abusers no rights, and the ACLU has supported a variety of initiatives to get at the criminal act, get at the prosecution of sexual assault for minors and the many other state and federal laws that might be broken when some child is actually abused during the filming or in any other way a victim of child abuse. But not to get at the pictures, but to get at the actions, even though getting at the actions is obviously more difficult. Well, it's more difficult, but if you cannot get to the actual underlying abuse, I think you haven't solved any problem at all.
Yes, here in the front row you had a
On this
question.
very issue, excuse me, Judith Reisman from the project on research on Playboy, Penthouse, and Hustler. I have a question. Wasn't it the ACLU that presented the argument before the Supreme Court in defense in the New York Court of Appeals in the defense of the use of children in sexual creation of sexual imagery, which we could call, I suppose, pornography for want of a better word? And if that's the case, what was the defense of the ACLU at the time?
We were a participant in the Ferber case, which in our view had to do with the First Amendment rights of the distribution of the material. It in no way suggested that the ACLU supports the sexual abuse of children, or that it endorses it, or that it thinks it's maybe okay. It's been very clear that the sexual abuse of children can be criminalized. There can be both civil and criminal actions taken against the abusers, whether they are using them children to make films or whether they are simply abusing the child in their home. The abuse of children has no First Amendment protection. Literature, pictures, may have some, although, as again I want to admit, the Supreme Court says essentially that the governments can do anything they want to stop child pornography.
And what's your position? Do you agree with that?
No, we don't agree with that. We did argue the case. I'm not trying to deny that. I'm just trying to suggest that even though the Supreme Court has essentially allowed it to be outlawed, Congress and virtually every state has passed legislation, the level of sexual child abuse in this country has continued to rise. I think it demonstrates that there's something at issue here beyond pictures.
Yes, back here in the middle. Joe?
Question to Mr. Lynn concerning child pornography. Is not the distribution of child pornography an act of accomplice to the creating of the picture, in the same way that if I offered Dave $1,000 for a picture of somebody shooting another person and he went out and arranged that shooting so he could take the picture, a means by which I am aiding and abetting the shooting of that person?
Yeah, we have, I think, indicated also that it is possible under the criminal law to reach through aiding and abetting and similar kinds of measures of liability persons who willfully participate in the abuse of a child. Again, the issue is not whether they were abusing them and taking a picture. The issue was whether they were abused at all. If so, normal criminal liability may extend to second and third parties, and that is certainly without First Amendment protection.
A follow-up to that. Is a child capable of consenting to any form of sexual activity?
Is a child capable of consenting? I think it's impossible to make an argument of meaningful consent. I suppose there are gray areas when you reach 17 and a half, but no, I don't personally think you can agree to engage in sex at the age of 5, no.
Yes, right here.
I'm Italizioni. I have a question to, I'm a sociologist of sort. I have a question to Mr. Hudson. I'm worried about your budget. Somebody complained that it's too abundant. I wonder if it's quite satisfactory. The social science questions you said you're going to cover, I could see you need several $1 million per any sub-question. I'm concerned if public hearings are a source of the kind of evidence for these questions. The one example you gave had a chilling effect on me. When you said that one publisher, a spokesperson for a publisher association answered to a question if it had chilling effect, no, and you could use this as evidence. This is not a legal question, this is a scientific question. I don't think any sociologist alive, even from South Carolina, would accept this as evidence.
Well, you have to understand that the testimony of Mr. Townsend will be considered along with all the other evidence we have before us. I'm just citing that as an example. Mr. Lynn indicated that publishers weren't in any way fettered by the definition of pornography, and he, Mr. Townsend, Mr. Hoops Townsend, is the director of the American Publishers Association, and as such is their spokesman, and he indicated that it had no chilling effect. With respect to the budget, I would agree that there are a lot of scientific issues here that are going to require a great deal of study. That has been entrusted to the scientific staff that we have. They indicate that they can achieve their goals with the money they have at hand. I trust their judgment. I am not a behavioral or social scientist, but they've indicated with the assistance of other governmental agencies that are willing to expend their resources, our goals can be accomplished within the budgetary framework that's been set.
Very briefly, I'd like to make a very minor contribution to the work of the Commission. Without any charge or fee, I'll prove to any jury's satisfaction that the staff is deceptive.
I'm sorry, I couldn't
If the
understand.
staff came and told you that within the budget available to them, they can answer these scientific questions scientifically, they should be under the Department of Justice investigation. They're clearly engaging in deceptive behavior.
Yes, right here. I think you've been waiting.
Yeah, there's one issue that I think has dominated the questions about the effect of pornography, and I think there's pretty well agreement on both sides that it's sensible to say that the distribution of pornography or looking at pornography is essentially harmless. However, I wonder whether there is also agreement that the conditions that are brought about in the production of it, that is, the taking of a photograph, whatever, especially with children, but also in pornography that doesn't involve children, whether those conditions are oppressive enough and represent enough discrimination so that you could actually call pornography a danger without having to collect information about 99% of rapists or whatever. I'd like to get opinions from both of the speakers on this.
As I mentioned, the method of production and distribution of pornography is one of the areas that we're going to study. Your observations may very well be well taken. At this point, I really can't speak on behalf of the Commission, but it's certainly something we're going to take into consideration. One other thing I want to take the liberty of commenting on, if I could, Mr. Lynn has mentioned that he feels that pornography involving children, if it should be controlled at all, should be controlled only as far as the people that participate in the manufacturing. Well, ladies and gentlemen, I think as you will be aware, it's very difficult for any law enforcement effort to ever control any type of illicit item if it concentrates only on the production and not, or rather allows also a market to flourish. You've got to control both aspects of it in order to interdict the flow of any type of illicit material, whether it be drugs or whether it be pornography. So I think law enforcement has to look at both ends of the issue if we decide that it's something that we want to make recommendations on.
There is some evidence about the production process of adult pornographic film, and there's, like evidence in many other areas, evidence is in dispute. There were witnesses who testified before Senator Arlen Specter's Subcommittee on Juvenile Justice last fall who said that they had been coerced, physically coerced, into the production of pornographic films. There were other actresses from so-called pornographic films who indicated that they have not themselves, nor are they in any way aware of others who were coerced into the production of material. So there is evidence. It is in dispute. And I think it is certainly not self-evident that a large number of people are being coerced into the production of this material. That's not to say that it's the position of first choice for people who have limited job options. I'm sure it isn't. But I'm also sure that the answer for that problem is not creating more laws on pornography and obscenity.
Yes, right here.
Twist Butler with the National Organization for Women with a question for Mr. Lynn. I'm not sure whether your presentation today included the idea that that you are often found in the position of defending unpopular ideas, but I think it is a common theme in your presentations. And I wanted to ask you whether you feel that the evidence really supports that point of view, but rather does not support the point of view that you are presenting a brief for the status quo, given the fact that despite the focus on the First Amendment, we may be overlooking the 14th Amendment position, which is an impaired one, of a great number of the people who are the subject matter for the pornography. It seems to me that that plus the evidence of the business which you cite might indicate, and also other indications, societal ones that everybody is very well aware of, might indicate that indeed you are presenting a brief for the status quo.
Well, I think that it is not accurate to say that most people utilize or read pornography. I mean, I think that the evidence of the few surveys, flawed as they might be, suggests that most people are able to go through most or all of their lives without using the stuff. So I'm not sure whether I'm defending the majority's view or the minority's view. But I think the other important part of your question is, are we forgetting something here about victims, about people who are discriminated against on the basis of sex? And I know that this is the position taken by some, but not all members of NOW, and I think this is the position taken by some, but not all people in the feminist community generally. I don't think that there is any evidence to suggest that pornography plays a central role in sex discrimination in our society. Unless you happen to work in the Adam and Eve bookstore, you are not exposed to graphic, sexually explicit images for more than a tiny fraction of your life. Instead, you are seeing demeaning images of women in commercials, in TV programming, on record albums. You are seeing it in the dishwashing detergent commercials on television. You're seeing them in regular situation comedies and all over the rest of the mass media. It doesn't even make any empirical sense to suggest that the central role in sex discrimination is caused by pornography. That's simply an untested, unverified, and I think irrational assumption upon which to base the suppression of sexually oriented material.